Welcome to a new section of Business Law 2. We've completed the one about the different organizational forms under the law for businesses, which we looked at sole proprietorships, partnerships, corporations, and all the permutations in between those. Now we're going to kind of move on, although we've touched on this a little bit when I was talking about capture and administrative agencies. We're going to move on to some uh, more diverse, actually, kind of catch-all. A lot of these are not directly related chapters towards the end of your text. And we're going to start off with talking about administrative agencies, which is something that the general public doesn't really, I think, understand how important they are. Certainly before I went to law school, I had very little knowledge of them. And even afterwards, I found that almost nobody thinks about them. If they do think a little bit about administrative law, they tend to have very negative opinions about it and a lot of misconceptions. So hopefully this chapter, which is really just an introduction to the whole concept of administrative agencies, should help dispel some of those, maybe give you a background in it. If but again, I can only touch the surface here. This is a complete course that you would take in law school, a 16 or 18-week course, meeting 3 hours a week, and we're only going to spend less than an hour looking at it. So we're going to skim over the surface, but I'm going to try to give you some of the important language and some of the important structure of it. Okay, so first of all, how significant are they? Here's the surprise I think most people don't understand. That most law in America today is made, is enforced, and the consequences, so legislatively, executively, judicially, is done by administrative agencies. I think this is in part because if you've got a country like the United States with over 300 million people in it, and you have a legislature that has 435 members in the House and 100 in the Senate, so it's 500 people roughly, and you've got a court system that at the top, the Supreme Court, has 9, and you have a single president. That's a shockingly small number of people to keep an eye on 300 million. So a lot of that power has to be delegated out, and that's what an administrative agency is. It's when, in particular, Congress has decided that they needed experts to monitor, control, legislate, enforce, try certain areas of both the economy and society in general. There is a cost for this, and there's also lots and lots of agencies we can talk about. If you go to the 15th edition, you'll see that there's a chart of just some of the federal agencies. And remember, of course, that although I'm going to talk pretty much exclusively about federal agencies, most federal agencies, or a lot of federal agencies, are duplicated in the state level. So yes, there's an Internal Revenue Service, but North Carolina also has a Department of Revenue. Yes, there's an Environmental Protection Agency, but all states will probably have something similar to it. Wyoming might have, and I don't know what Wyoming's actually is, their Department of Environmental Protection. Now, these agencies come at a cost to business. Some of the numbers that were thrown around in this edition and early editions of your text said that all federal regulations cost up to $7,000 per employee. This drops to about $4,500 if you're a larger company. And these can be things like environmental, where you have to provide masks if they're working in a toxic environment. They can be economic, where you say, okay, well, there is a minimum wage. That's a debate we're having right now in the United States. The minimum wage is $7.25. It's been there for quite a long period of time. The argument now is to raise it to 15. Well, if you raised it to 15, of course, you're going to see an increase in that amount of money. There's workplace regulations, and these can be things as simple as you can't discriminate against the elderly, or you can't discriminate against people based on gender or religion. And also tax regulations. So if you think about the IRS, I've already mentioned them as an administrative agency. Congress can't create a detailed tax code, it would be all it would do. So the one who creates it is the Internal Revenue Service under the authority of Congress. The next thing is, what do they do? Well, they're a regulatory function in theory. But having said that, I think it's also true if you look at them that they really do um, essentially function much like mini governments. They're going to issue orders, they're going to issue rules, they're going to make decisions. In many ways, you can say that they legislate like a Congress, creating rules. They do investigations like the executive branch would, like the FBI does, and they're going to have trials, and they're going to be able to hand down fines. So we talked in the last chapter about the Securities and Exchange Commission having the authority to fine people for violations of Securities and Exchange rules. Okay, so how do we create these things? How do they come into existence? The first thing that has to happen is, because they can't come into existence accidentally, is that Congress, and I'm going to just talk about the federal, Congress has to decide they're going to create an agency. So maybe there is some issue out there that they really feel, we need a specific agency for it. So, at the turn of the last century, from the 19th to the 20th century, there was a huge scandal in the United States about tainted meat. And Congress, under some pressure, eventually started to regulate. And eventually, this evolves into the Food and Drug Administration, regulates food, and they say things like, okay, it has to be this sanitary, or if you're selling beef, it has to be beef. It can't be horse. It can't be chicken. It can't be whatever. So, what do? They create rules. So it could be like the IRS saying, okay, we're going to create a rule about how much of your capital goods you can depreciate. If you've got a car, a truck, a house, this is the percentage depreciation we'll allow. They investigate businesses both for violation of the rules they created, but also to see if new rules or anything is necessary. They publish these findings. They should be, not always are, semi-transparent. They have the authority to hold trials. So we talked about how the Securities and Exchange Commission in our last chapter had the right to investigate stock fraud, issues like that. And they could fine people. Now, you have to understand that enabling is only going to be what Congress decides they're going to let them regulate. And you can have huge fights about this. For years and years and years, if we go back to the Food and Drug Administration, the Food and Drug Administration said nicotine is delivered via cigarettes. And cigarettes are essentially a delivery mechanism for a drug, the drug being nicotine. And we should be able to regulate it. And that was a huge fight. Congress was hesitant to grant them that power, in part because the tobacco lobby was so powerful. Do you think that the Food and Drug Administration should be able to regulate tobacco? Arguably regulated out of existence, since it's a toxic substance. So that was, one of the fights. And Congress can say, yes, you can, no, you can't, although sometimes the agencies will interpret what they mean. Okay. There are different types of agencies we could talk about. The two major types that we see are your executive agencies and your independent agencies. So an executive agency is directly under the control of the President of the United States, or governor if it's a state agency. So an example of that would be the head of the IRS. Who's the head of the IRS? Whoever the President of the United States wants him to be. Who's the head of the EPA? Whoever the President of the United States wants him to be. The President controls it. Now, of course, that's a direct control, and it's just the top guy or the top few guys, and then you have the bureaucracy underneath. Independent regulatory agencies, they're outside the direct control of the president. Congress may decide how they're going to set them up. The president may appoint someone, but he won't necessarily have the power to remove them. So I'm going to talk about a quasi-administrative agency, and it's a way that most of you have probably heard of it, the Federal Reserve. The Federal Reserve, admittedly not a perfect fit here with independent regulatory agencies. The head of the Federal Reserve, the chairman of the Federal Reserve, is appointed by the President of the United States. Once that person's in power, the president can't remove them. They're going to serve a fixed term. So last time it was for the current head of the Federal Reserve was Janet Llewellyn. When she got her term, even though she was appointed by Barack Obama initially, when she got her term and then Trump got elected, Trump did not have the power to remove her because she was independent. And that was intentional because the powers that be really thought it's a good idea to have parts of the economy immune from direct political pressure. So they are independent agencies, are fixed terms. There is, some input on deciding who they are, and sometimes getting them confirmed by Congress. So there's influence there. But once they're in office, they're in office. Absent them committing a crime, they're there. And the rationale for that is that an independent agency will not be subject to the winds of political pressure. Okay, so I've said a couple times that they really mimic the government. Most administrative agencies, you can look at them and say, well, this functions just like the federal government. They can pass laws. So the IRS can come up with a new regulation, the EPA can come up with a new regulation, the SEC can come up with a new regulation. They then can enforce those regulations. So if the IRS says, okay, this year I think they're pushing back the date for tax filing from April to, I think they're pushing back to March, but I'm not positive. If the IRS decides that, they can do it. Now, if they say you're going to pay your taxes by March 15th, if you don't, they can investigate you. And if you don't pay, they can bring you into a court. So they can, and they don't call it a trial, they call it an adjudication. But they can hold a trial. You can wind up in an IRS court. So they are, this power derives from Congress. And if you look at Article 1, Section 1, this grants the legislative power to Congress. And Article 1, Section 8 says they can do whatever is necessary and proper to carry out the other powers granted herein. So that's where Congress gets the authority to really create these things. Now, the basis for how the judiciary deals with them, because we're really focused on the law, maybe making the law a little bit, maybe enforcing the law a little bit, but certainly the adjudication of the law. The courts have clearly recognized that Congress has the power to create these administrative agencies, and that these agencies then can legislate, enforce, and adjudicate. This is called the administrative process. And sometimes, of course, when we talk about judicial process, we're talking about the administration of laws by the courts that are created elsewhere, by Congress, typically federally. Sometimes the laws or regulations created by these administrative agencies can wind up in regular court, but usually not. Now, Congress passed the Administrative Procedures Act because they wanted to prevent these agencies from becoming tyrannical, from becoming just out of control, doing whatever they want. So all agencies have to follow congressional instructions in how they proceed and do things. And one of the big parts of this is what's called the arbitrary and capricious test. The Administrative Procedure Act says if you're going to come up with a new rule, the first thing you've got to do is you've got to give us a rational explanation for why you're getting the rule. It just can't simply be because. I know we all, as children, maybe as parents now, when we're questioned by our children, we've heard the famous answer, because. Why should I have to do this? Because I'm your parent. Well, if I ask the IRS, why should I have to do this? And the IRS just says, because we're the IRS, it's not a good enough reason. There has to be a rational explanation. They are also not allowed to change prior policy without a clear justification. So if you're going to go from having a 10-year deduction for certain capital goods to a 20-year deduction for certain capital goods, you've got to come up with a rational explanation for it. You can't consider a legally inappropriate factor. So you can't say, well, the reason we're doing this is that it's going to benefit the state of Wisconsin. you can't fail to consider a relevant factor. If you say, well, yeah, this new regulation is going to cost billions and billions of dollars, but we're not concerned with that. No, you have to be concerned. We'll talk about cost and benefit analysis a little later. And you can't render a finding plainly contrary to evidence. Now, you'll notice that these really create causes of action almost, within which people can sue agencies when they change. And that's why when you saw in the last administration, I think we saw a good example of that, when the Trump administration wanted to change certain rules, and they said, okay, well, we want to get rid of these environmental protections, so we're going to have the EPA issue new regulation. Well, they were sued under the Administrative Procedure Act, saying, well, you didn't follow procedure. You all of a sudden said we're going to allow more carbon dioxide in the air. We're going to allow more of this. Well, you didn't consider appropriate factors. You didn't provide a rational explanation. You just changed it for political reason, which might be good enough, but usually isn't. Okay, the rulemaking procedure. How do we get a rule in the first place? Well, of course, they have to regulate within the power of their enabling statute. So the IRS can't decide to regulate the Endangered Species Act. They've got to be given the power. So let's get away from the IRS because it's a frightening organization in a lot of ways. Although I think it's sometimes unfairly chastised. Let's take the Environmental Protection Act. So let's suppose that the IRS decides that a type of bird is endangered, and they say, oh, okay, the ivory-billed woodpecker is an endangered bird. So we're going to have a rule that you can't establish an industrial concern within 500 yards of a ivory-billed woodpecker's nest. I'm just making something up. The EPA would have that power. Now, sometimes the EPA is just going to give a interpretive rule. So sometimes it says 500 yards to the nest, and they said, okay, well, we mean that to be 500 yards in walking distance, not straight line. So if you're on a hill and there's a hill in between and it's 200 yards to walk up and then 300 yards to walk down, it's an uneven hill, but it's only 100 yards straight, that's still 500. Interpretive rules are generally exempt from perfect APA, and one of the things that has to happen first when we give any rules is notice and comment rulemaking, assuming they're not interpretive. This is the most common thing you're going to see. Notice and comment rulemaking is essentially letting people know that we're getting ready to put a new regulation out. So first of all, the agency says, here is our proposed rule. We want to protect woodpeckers. Here's our authority to do it, the Endangered Species Act. Here's the subject matter, protection of woodpeckers. Okay, they then have a comment period in which people can give opinions. They can write in, they can talk, they can testify about the rule. And people might say, well, 500 is too much, or 500 is not enough, or you should protect red cockaded woodpeckers too. You could put all these comments in. The agency responds, and they have to respond generally to any serious comment, certainly any substantive comment, and they can at this point modify the rule, again, within the APA. When this process is done, they issue the final rule, and this rule is published in the U.S. Federal Registry, which is published every day of the year, I think, except Christmas Day. Now, sometimes people want to appeal these rules, and they want to get into court. And a very important case came up. It's called the Chevron case, and more about that in just a sec. But basically, the Supreme Court had to decide how much leeway would the courts give to the agencies. How much would they say, well, the agencies know what they're doing and we do not know much about it, we're going to defer to this. The Supreme Court has ruled that courts should defer to the agency's interpretation of facts and, most astoundingly, the law. So they ask, one, did Congress address this in a statute? Is it clear? Well, if it's clear, then that's it. If the statute is silent or ambiguous, then we ask, is the agency's rule reasonable? And if it is, That's it. The rule stands. Now this came out of the Chevron case, which is a very controversial case. Um, let's talk about investigation. The second one. So you can have a rule. Now we can have investigation to find out what's going on. Now this can be just we're gathering information. We're thinking about coming up with a rule. Maybe it can precede or can come after. We're thinking about coming up with a rule about woodpeckers. So we want to go out and find out how many woodpeckers there are. We're going to gather information. Or we've got this rule and we want to see, is it working? Or we've had lots and lots of complaints about this rule. Let's go out and see how it's functioning there. So you can do all those things. You also can do inspection and testing. So, if you're the Nuclear Regulatory Commission, you can go to places like Sharon Harris Nuclear Reactor here in North Carolina, and you can inspect. You also can say, okay, you're supposed to turn in material, how much radiation leaked every, quarter, every day, every month, whatever it is. We want to review that. Now, they have the power of subpoena, and this is really important. We're going to use a couple quick Latin terms. The two basic types of subpoenas are called subpoena ad testifictium and a subpoena duc detectium, which is either we're going to subpoena you to come in and give me testimony. Sometimes we can do this written, but we can do it orally as well, and we'll keep a record of it. Or in duc detectium, we want you to produce something. Give us the dosimetry readers for your radiation. Give us the total reported number of births of these woodpeckers. Give us the total amount of money you deducted, whatever it is, as a record. Now, you can protest these. You can say, look, this is not a legitimate investigation. You can say they're not seeking relevant information. You can say that it's not specific enough. But generally, you have to obey these. They also have the power, if they need to execute search warrants. So again, they've got to meet the standard of, was there enough probable cause? Was there a reason for this? But in some areas they don't. Certain highly regulated industries that are very dangerous, like nuclear power, they don't need the same level of probable cause. In fact, if you're going to operate a nuclear reactor, you waive your search warrant requirements. The Nuclear Regulatory Commission can come in anytime it wants, in any situation, and enter that plant and search it. Certainly they could do it if there was some sort of meltdown or problem. Okay, so we've made the law. Okay, so we've issued the rule. We've investigated it, and sometimes maybe we enforced it. Now we're going to have an adjudication. What's the most common thing? Well, there's a negotiated settlement. The EPA comes to you and says, you're discharging too much water into the river that's got these chemicals in it. Stop it, please. Well, I can't stop it completely. How about if I stop 90%? No, we want 100. We want 95. Well, how about 92? Okay, we'll settle on that. And this is the most common way that violations of these are settled, and this can be either very formal or informal. Formal complaints only arise if you can't reach this kind of informal, please do it this way. A complaint is a public document. If there's no settlement, if the agency says, please, I want you to limit the amount of chemicals you're dumping, and the company says no, and they try to negotiate, well, how about you cut it down by 50%, and the company says no. All right, well, we've investigated. Now we're going to bring you in front of an administrative law judge, an ALJ. So the ALJ essentially operates just like a judge in a courtroom, except he's just working for the agency. Now, in theory, he is separate from the agency. So it can happen, and here would be kind of a nightmare for a lot of people. I keep picking on the IRS, but it's what most people know. You mess up an IRS deduction, they tell you you need to pay, you disagree, the IRS says you need to pay, you wind up in front of an IRS judge, administrative law judge. Now, in theory, this administrative law judge has lots of power, and he's supposed to be neutral. He holds hearings. There are oaths in his courtroom or her courtroom. She takes testimony. She rules on the admissibility of evidence, and she makes determination of fact. As I said, there he is. I keep changing gender pronouns just so we can have some level of equality here. He is supposed to be neutral. and he is supposed to be in a separate division from who he's working for. So if you have an IRS judge, she is not supposed to favor the IRS. She's not supposed to engage in ex parte or private conversations between the agency, so the people that are prosecuting you. She's supposed to be neutral. And if the agency retaliates against her for not doing that, that she has some protection. Now, this is sometimes not honored in the breach. An example would be an administrative agency like the Immigration Service. There are Immigration Service judges that are, there's some evidence to show that they have been punished if they don't fine for the agencies, or they don't fine fast enough. Okay, the hearings typically are pretty informal. What you're going to see is basically the first thing is discovery. Let's find out what people know. The second thing is maybe there's depositions or interrogatories or requests for documents. So you gotta have the facts first that go in front of the judge, and probably before you're actually in front of the judge themselves, all this has been done. Everybody knows what the facts are. There's no surprise evidence. There's none of that crud. People pretty much know. The next thing that goes on is the judge hears it and gives an order. He says, okay, this is what I think should happen. And this is called the initial order. Now, if you're not happy with it, you can appeal. And you're going to appeal usually inside the agency. Sometimes you can get outside the agency. If you don't appeal, that order, that initial order, becomes the permanent order, the final order. Now, there are some dangers here. Obviously, these administrative agencies could become very tyrannical, very powerful, and it does concentrate a lot of power. There are some benefits, however. In theory, they've got the specialized knowledge. If you think about, let's suppose you wanted to regulate medical procedures. Well, just looking at Congress, how many people in Congress are experts in regards to medical devices like wheelchairs or hip transplants? Well, there might be one or two doctors in Congress, and they may or may not be in the party that controls the Congress at the moment, and they may or may not be on the right committee. So Congress might not have the specialized knowledge that is necessary. Often, too, Congress is very busy. They're busy doing all sorts of things. They've got to regulate the rest of America. So sometimes they can't deal with these minor issues. Those are some of the benefits. Now, I did mention this before, but I wanted to give you a reference to it. Chevron USA Incorporated versus National Resource Defense Council came down in 1984. Historically, the courts would say it's up to the agency to decide factual issues. The agency has the experts. The courts aren't going to second guess them. But when it comes to interpreting, did the agency act within its legal power? Since that's really a legal issue, let's leave that with the courts. But Chevron said no. Chevron said, we're going to turn it over to the agencies. We're going to say that they get to make the decision about this. It's pretty shocking. What it does is it gives the agencies not only power to determine what the truth is, but determine whether they should even hear the cases and how they should hear them. Okay, so they ask, did Congress address the issue in dispute? If there's statutory language, and if it's silent, did the agency do what was reasonable? Even if what it did was reasonable is not what the courts would have done. So it gives a tremendous amount of power to these agencies. All right, when the courts do get involved, what questions do they ask? Well, they say, first and foremost, did the agency exceed its authority? They're often very interested in, is it outside the scope of the enabling statute? Has the agency given a proper interpretation of the law? Was there a constitutional violation? Because they can't, just say, well, we're just going to conduct searches of private homes when we feel like it because we're an agency. Did they follow the APA? Did the agency act in an arbitrary, capricious, or abusive manner as it has discretion? And were the conclusions whatever it arrived at, supported by substantial evidence. And this is really not a very high standard, although it would seem to be. And it gives the agencies a lot of power and deference. Um, there is also what's called the exhaustion doctrine and the ripeness doctrine here, where essentially if you're going to protest, if you don't like what the IRS did about your taxes, you got to go through the IRS court first. So when I would represent people in front of the IRS, I would go in front of an IRS judge first. And then usually if there's a fine or there's a finding, in order to get to federal court and get any sort of regular trial, you've got to basically pay everything and then go to court. You've got to exhaust all your IRS options. Ripeness, of course, you have to have standing, you got something at risk, and there has to be an actual controversy. You can't just be sticking your nose in for no good reason. So how are these agencies controlled if they have this much power? Well, of course, the president can fire federal employees, and he has veto power if he doesn't like what Congress decided. So he doesn't like what the IRS is doing, put someone new in. Doesn't like what the EPA is doing, put someone new in. There's legislative controls. You don't like that the Food and Drug Administration regulates tobacco, change the enabling statute if you're Congress. You do want it to regulate it, change the enabling statute. Control funding. This is one of the things that's happened to the IRS, why we don't have a very effective tax system, is that we've starved the IRS. I've been picking on the IRS, so let me be a little bit good to them for a minute here. We've starved the IRS for funds. If you don't like what they're doing, don't give them the money to do things. You can investigate the agency with what they're doing. You can propose freezes, and we'll talk about some of those, for new regulations. And of course, you can enforce, modify, strengthen the Administrative Procedure Act. Some of the things that have been done is there have been different laws passed. So one of the big ones is freedom of information. Agencies have to disclose to the public records. Certain records, not all records, there can be private records, and this is enforceable by the federal courts. And in fact, after 1996, most of these records have to be available online. Now, there's always pushback here under freedom of information, and some agencies, like the Department of Defense, for example, have gotten very good at saying, that's really not subject to it, or we'll do this, but we're undermanned, and it'll take us 6 months or a year to get your information. Government and Sunshine Act. This was passed in 1976, and it mandates that if you're going to have meetings about something, they better be in the open. As a matter of fact, way back in the 1990s, when Bill Clinton's wife, Hillary Clinton, was in charge of crafting what would have been the first National Health Care Act, she had a lot of meetings with people, doctors groups, insurance groups, medical device groups, and they weren't in public, and it was a violation of the Sunshine Act. Now there can be exceptions if whatever investigation or meetings are the result of criminal charges, or if it's going to frustrate the implementation of the rule, or if it concerns future litigation or rulemaking. But again, we generally like things to be in public so that everybody knows what's going on. That's how democracies function. Regulatory Flexibility Act in 1980, if the legislation has significant impact on a substantial number of entities, you've got to conduct a rule to see if there's alternatives that are less burdensome, things that'll work but aren't as bad. In 1996, we had the Small Business Regulatory Enforcement Act, which says Congress should review new regulations for 60 days before they become effective. And there was some more cost-benefit put in there, and they said if you're a small business, you can complain to the National Enforcement Ombudsman and actually recover some legal costs and sometimes stop some of these rules. Now, I've kept talking about federal agencies, but again, like I said, there are parallel state agencies. If you've got the IRS, you've got the North Carolina Department of Revenue. If you've got the Interstate, well, not a lot of Commerce Commission, because there's some areas where there aren't. There's no state nuclear regulatory commission. If there's a conflict between what the state wants and the feds want, the feds win because of the supremacy clause of the U.S. Constitution. Okay, well that gets us in at right about half an hour, and whenever you're ready, click to the next chapter.